Hello and welcome to Hunt and Hunt's litigation team as we discuss the players involved in litigation or the ADR process, the alternative dispute resolution process. Of course, we're lawyers, so we'd like to start talking about lawyers first. And to do that, I've got Catherine Ballantyne, who is the head of Hunt and Hunt's litigation team in Melbourne. So, Catherine, tell me what a lawyer's role is in a litigation or negotiation or mediation.
Well, a lawyer's role, first and foremost, is to put the best case forward for you possible, to advise you as to the risks, and to help you with strategy. You have to remember we do this day in and day out. So there's a lot of strategy in litigation. And so the benefit of having an experienced lawyer is not just the pure legal side of it, but it's the strategy to get the best result possible, whether it's a negotiated settlement or whether it's at trial.
Mm. And it's important, isn't it, that it's not just one lawyer involved, it's normally a team of lawyers. So, you've got industry experts. Yeah. So in some cases, you might involve somebody from our commercial team in the litigation as well. So it's not just litigators, it's not just those involved, it's a team.
No, absolutely. And there's different areas. So, you'll have litigation about property disputes or litigation about trademarks or shareholdings or some banking and finance issue. And so we have specialists in all those areas who are able to assist the litigation team with their specialist knowledge.
Excellent. Now tell me about a mediator. What's their background, likely background, and what's their role?
So a mediator often has been a lawyer, but not always. Sometimes they're from a particular industry, so they understand the industry jargon and the technicalities of a specific industry. And what their role is, they're an independent person who doesn't know either party, and they come in and they come in to facilitate the negotiations and facilitate a settlement. So they don't determine the dispute for the parties. They're there to try and get the parties to negotiate with each other and be an independent person to be able to facilitate that.
Excellent, cool. And an arbitrator. What's the difference between the arbitrator and a mediator?
So an arbitration is a mini court case. It's a more streamlined court case without necessarily all the rules of evidence and all of that type of thing. So an arbitrator will determine the dispute. They won't be like a mediator who's not there to determine it, who's there to negotiate an outcome. An arbitrator will determine it, but they may not be a lawyer. They may be someone from that industry, and they will hear the evidence and hear submissions and then determine it. So they're like a judge, but it's a much more streamlined and simpler process.
And is the outcome binding from the arbitrator?
It is, and that is one of the downsides from arbitration. It is often very difficult to appeal an arbitrator's decision, whereas when you're in the courts, you have very tried and true ways of appealing and ways of going to the Court of Appeal. Whereas with an arbitration, it is more difficult to appeal. And that's something the parties have to weigh up when determining whether to go down an arbitration process or a litigation process.
Okay. And that's quickly, what's the difference between a court and a tribunal? So if we end up at VCAT versus the Supreme Court, what's the most functional difference between them?
Well, it's what type of cases they hear. So VCAT has specific lists, like the retail leases list. So there are some cases that must go to VCAT. The courts don't have jurisdiction over them. And then there are other cases that VCAT can't hear, say a lot of your Corporations Act cases where they must be heard by a court.
Mhm. And a VCAT decision, is that enforceable or do you need to look at another court if somebody doesn't want to pay?
A VCAT decision is enforceable. You need to get it to go through the magistrate's court to turn it into an enforceable order, but that's a very simple process, and they explain how to do that on the website. So when a VCAT makes a decision, it is enforceable.
Cool. Under the court process, I mean, what's involved in getting a case to court?
So you start off and there's two types. You can do an originating process and an affidavit or a statement of claim. But either way, they're essentially something that tells your story, that tells your case. Then the other side gets an opportunity to respond and put in a defense or affidavit material telling their side of the story. And it goes through a process. Once you've done that, sometimes there's requests for more material, more particulars, documents, all of that leading up to evidence, witnesses, who's going to support each side's story, what are they going to say, sometimes expert witnesses if you need someone independent to look at, say, valuing a company or valuing a property or something specific, a technical specific thing that the court might not know without an expert. And then you go to court and then you go to trial. But there's a whole heap of steps along the way. The courts also do try to get people to settle along the way. So there is almost always a court-ordered mediation where the court requires the parties to attend a mediation with an independent mediator to try and settle along the way. And the courts also encourage offers along the way, even outside of the mediation process.
Now, a couple of words to talk about. Tell me about discovery.
So discovery is the process by which each party provides the documents to each other that are relevant to the case. And you're meant to provide documents whether they harm or help your case. You're not meant to just provide the helpful ones. And it's in many cases ordered and a required process so that the parties can see all the information relevant before they get to trial, so that they know their prospects and everybody sees all the information. Both parties are working off the same material as the judge.
And how much of a role does legal professional privilege play in litigation?
Well, it's incredibly important. Legal professional privilege is essentially where what you tell your lawyer cannot be disclosed without your permission to the court or to another party or to a third party. So it's incredibly important so that parties can feel free to share the good, the bad, the ugly of their case, and the lawyers can really put them in the best position and put the best case forward for them and create the best strategy to get a good result.
And it encourages honesty from the between the client and the lawyer, doesn't it?
Yeah, that's right, which is so important because there's nothing worse for a lawyer than getting to trial and something coming out that the client just didn't want to tell you about. Whereas had you known beforehand, you could have dealt with it, maybe got another witness, an expert report, or made submissions. Whereas when it comes out of left field, it's often too late to be able to deal with it properly.
And for those of us in Australia, it's not like America, is it? Like you don't stand there and address the judge or question people. We have barristers for that.
Well, that's right. So we have what's called a split profession over here. So we have the solicitors who do a lot of the preparatory work with the barristers, and the barristers are the one who stands up and presents to the court. So in most cases, you'll have a barrister and a solicitor working on your case.
So the barrister's the one with the wig, and you don't have to wear a wig.
Well, they don't have wigs anymore, only gowns. Only
Well, there
gowns.
you go. Only.
They got rid of
All
the
right. Yeah, now a couple of last ones. The industry ombudsman. I mean, a lot of industries have them. What role do they play?
So that's a separate matter to litigation. So if someone has a complaint, say in the banking industry, the finance industry, a whole heap of industries, they can make their complaint to the ombudsman, and the ombudsman will then determine the complaint if it falls within the ambit of their jurisdiction, and they'll ask whoever you're complaining about for documents and to give their side of the story, and then they'll make a decision. And it's usually a very cost-effective, usually free service that's provided, and it is binding.
Okay, so you can't argue with that and end up in litigation?
Well, it can be appealed, so it can, but it is a determination that often people will adhere to, but it can be appealed.
But it's obviously not suitable in every case, is it? There's only some issues will be solved by that.
Well, only some issues, and they sometimes have a limit as to how much they're allowed to award as well. So sometimes litigation is far more preferable.
And what about some of the specialist alternative dispute resolution bodies that are around? I mean, what role do they play, and what are they?
Yeah, they're fantastic. They're good often for your smaller disputes. They're good, and they're often good when people don't have lawyers as well. So if neither party has a lawyer, they're very good because they will provide a mediator, and both parties can go and essentially try and negotiate an outcome. In some cases, it is actually required before you can say make a VCAT claim. You have to go through that process, but it is actually a very good process and cost-effective process. And sometimes people do it even before they've got lawyers involved. And if it can be settled, fantastic.
Excellent. Well, that's the phrases that we need to know and the various entities that we need to know around litigation or alternative dispute resolution. So thank you, Catherine.
Thank you.